Good day, everyone. Welcome to today's webinar, Cross-Border Data Transfers in 2025, Regulatory Changes, AI Risk, and Operationalization. Today's agenda includes global data transfer updates, so we'll be giving you a kind of a tour of the globe here, talk about what the impact on privacy teams are, and go over some management strategies. So let's start with the US, the DOJ rules on the next slide. And this one could be its own webinar. We're going to give a brief overview, but there is a lot to this one. So in the US, the Justice Department, the DOJ, final rule implementing President Biden's Executive Order 14117 came into effect. This rule that was issued on December 27th of last year has significant implications for U.S. persons involved in the transaction of sensitive personal data with certain foreign entities. And we'll get a little bit more into what that means. It's crucial to understand the implementation timeline here. So the rule took effect on April 8th, which was 90 days after its publication. But importantly, the reporting requirements, specifically for restricted transactions, will be phased in and take effect later, after October 8th of this year. So 270 days post-publication. And this idea is this phased approach gives organizations time to prepare. So at the heart of this rule is the definition of sensitive personal data. The regulation targets transactions involving 6 specific categories of the data exceeding bulk transfer thresholds. So we'll get a little bit into what that is. The idea is if this type of data is exploited by a country of concern, which includes China, and that also, encompasses Hong Kong and Macau, Cuba, Iran, North Korea, Russia, and Venezuela, or a covered person. So that's an example of like an entity or an employee that's located in one of those countries, or potentially whose activities are controlled by one of those countries. So they don't necessarily have to be located in the country of concern, but may have some relationship outside that. And the idea is that, if the data could be exploited in such a way that could harm US national security. So that is the main reason why these protections are being put in place. The categories that are covered, as you see listed on this slide here, around covered personal identifiers. So like names are linked to a device, ID, your social security numbers, other government IDs. And threshold here is, over 100,000 US persons whose data is transferred over a 12-month period. So the thresholds apply across a 12-month period. So precise geolocation data like your GPS coordinates, the threshold there is 1,000, over 1,000 US devices. Those would be subject to this rule. Biometric identifiers like facial images, voice prints, retina scans, again, over 1,000 US persons. Human genomic data like DNA, genetic test results. This is bulk threshold is 100 US persons. So transfers at that threshold, the rules apply here. Personal health data, like your vital signs, test results, diagnosis, thresholds over 10,000 US persons, and then personal financial data being the last category, such as credit card details, bank account information for over 10,000 persons as well. It's important to note that certain data is excluded, like public or non-public data unrelated to individuals, like trade secrets, proprietary information, and then also personal communications that don't transfer information of any value. So it doesn't include, like, some of the sensitive categories that we just talked about. The rules place prohibitions and restrictions on U.S. persons engaging in certain covered data transactions with countries of concern or covered persons. And those key prohibited transactions include data brokerage, the sale or licensing of access to sensitive data, where the recipient didn't directly collect it. And then access to bulk human genomic data or biospecimens that which genomic data could be derived from. So those are prohibited. Um, Restricted transactions and transfers, they're permitted only if they meet the security requirements set by CISA. And restricted transactions include vendor employment and non-passive investment agreements. And then the CISA requirements focus on areas like cybersecurity policies, access controls, data security measures like encryption, and adopting privacy enhancing techniques. U.S. persons that are involved in the transaction must also ensure that the foreign entities that are receiving the information don't resell the data to countries of concern. So you really need to kind of understand that downstream data flow and you know who your partners are working with. And the rule also prohibits directing prohibited transactions and evasive practices. The rule also does include exemptions. It wouldn't be a rule if you didn't have some exemptions, such as personal communications, official U.S. government activities, certain financial services transactions, corporate group transactions for routine business. Transactions are required by law, and then there's other specific exemptions for um, telecommunications and drug device authorizations involving de-identified data. Now, while the rule doesn't impose universal compliance obligations, companies that are involved in restricted transactions must implement comprehensive compliance programs. This includes risk-based procedures for data flow verification, identifying sensitive data types, confirming transaction parties, who is receiving the data, and what protections, they have in place, tracking, the in-use vendor identification, also, having written security policies, annual audits, and a 10-year record keeping are also required. So, okay, the key tip here is, know your data flows, understand the requirements for each of these jurisdictions, because this new rule on sensitive personal data does have significant implications. So again, understanding the definitions, the prohibitions, restrictions, exemptions are key. And we encourage you to review the full rule and assess your organization's potential exposure. Again, know your data flows. And it is expected that the DOJ may issue further guidance and advisory opinions. So also staying informed is key on this matter as well. I'm going to turn things over to Machek, who's going to tell us what's going on with Ireland and TikTok.
Yeah, and thank you, Joanne, for this overview. It sounds like most of our topics today could be, their own topics for webinars. So, yes, TikTok. Earlier this month, the Irish Data Protection Commission, DPC, announced their final decision following an investigation into TikTok. The investigation covered the period between 2021, 2023, and they looked into the lawfulness of cross-border transfers and transparency. On the inquiry into transfers, it was found that the data of the EEA residents have been remotely accessed by TikTok staff in China. The DPC found that TikTok infringed the Article 46 of the GDPR. companies transferring personal information of the EEA residents to another jurisdictions based on standard contractual clauses must verify that the protection is essentially equivalent to the protections in the EEA. Think about using the tools such as transfer impact assessment. According to the DPC's decision, TikTok did not sufficiently address the scope of the divergence between the laws in the EEA and China. As noted by the DPC in their decision, TikTok did not address potential access by the Chinese authorities to personal information under their national security laws. So the DPC's decision took into the consideration the period before TikTok implemented their Project Clover initiative. The company, or per the company, the data of the EEA's users is now stored in Europe. Now, TikTok has 6 months to bring their operations into compliance, or they're facing the suspensions of the data transfers to China. On the transparency, the DPC found that the privacy notice from the 2021 did not include sufficient information regarding third countries where the personal information was transferred to. The decision included fine of 530 million euros. Additionally, this is important to know that as required by Article 60 of the GDPR, the decision draft was submitted to other data protection authorities, and there were no objections raised to the scope of the decision of the DPC. Another thing that is worth noting here, TikTok initially informed the DPC that no personal information of the EEA residents was stored on servers in China, but in April 2025, the company they informed the DPC that they discovered that they in fact stored some personal information there, and the personal information has been now deleted. We can move to the next slide, please. So just jumping here to North America, and the topic on the global CBPR data transfers. With the increasingly complex regulatory environment, government-backed certification schemes are sought after. One of these mechanisms is the Global Cross-Border Privacy Rules, CBPR, and the Asia Economic Cooperation, APEC CBPR framework. The global CBPR, this is a certification scheme that was established in 2022, and it has evolved from the APEC CBPR. The system, the CBPR scheme involves the role of an accountability agent, which is essential for the system. An accountability agent certifies companies, and they monitor the adherence to the program requirements. We have been accountability agent in the US. The country that wishes to operationalize the CBPR system must select an accountability agent. And for Canada, Canada was the founding member for both global and APEC CBPR forums, but the government has not selected an accountability agent, so the Canadian companies cannot participate in the system. So now the government intends to change this, and the public consultation on the Canadian implementation has been announced. Interested parties have until June the 30th to submit their replies. There are several areas that the government is seeking the answers on. Some of the areas are the accountability agent model. Here, the participating jurisdictions have some degree of flexibility on this. So, for example, in the United States, this is a private sector. Another area is whether the implementation should be staged or not. So, for example, whether they should first allow companies or whether they should first, roll out the CBPR certification for data controllers, and then as the next stage, think about PRP, or should it be rolled out at the same time? Um, and whether the Canadian implementation should also include the certifications against PIPEDA, which is the federal privacy law. The implementation of the global CBPR certifications in Canada will unlock opportunities for Canadian companies to expand trade to new jurisdictions, build trust with customers, certify against the government-backed mechanism. Canada has attained their GDPR adequacy, and the reliance on the GDPR as a transfer mechanism where applicable will become an important piece in building the Canadian company's data strategy. Can we move to another slide? So staying on the topic on the global CBPR and the APEC CBPR, but moving to another jurisdiction, Thailand. So earlier this month, the Thai government issued two guidance documents on the cross-border data transfers. One of those documents was a guidance document on the global CBPR and APEC CBPR. This is important to know that Thailand is a member country of APEC, which is the regional economic cooperation, but they do not participate in the APEC CBPR, and they do not participate in the global CBPR. Now with this document, the guidance document, this serves as a comprehensive information document on on some of the essential aspects of the CBPR scheme, such as they're explaining what the principles are, they're explaining what the program requirements are. They're explaining the roles of the accountability agents, the roles of the enforcement authorities. There is also important information on how the program requirements under CBPR map to the Thai data privacy protection regulation. And there's information on the potential benefits for Thai companies. So now, with Canada, Thailand, we can see that there is a growing number of jurisdictions globally that are recognizing the importance of frameworks such as the global CBPR. With that, Joanne, what are the developments in the UK?
Yeah, the UK definitely has some stuff going on if we go to the next slide. Um, you know, basically, the European Union, the EU assessment of the United Kingdom's UK data protection framework is what's going on here. The EU Commission previously deemed the UK's data protection adequate for data transfers. However, the EU Data Protection Board, the EDPB, has recently issued an opinion recommending further scrutiny as the UK is considering new data protection legislation. So the EU's Commission's initial draft decision, recognized that the UK's data protection laws largely align with GDPR. It also noticed that the UK's commitment to human rights and the establishment of, its investigatory powers tribunal. And despite this, the EDPB has highlighted some potential weaknesses. They recommended monitoring the UK's evolving data protection laws for any divergence from EU standards. And concerns also exist around onward data transfers to the UK and really, the necessity and proportionality of certain data processing exceptions. So what recently has happened on May 5th, the EDPB agreed to extend the sunset clause for the UK's adequacy decision to December 27th of this year. So this extension follows the introduction of the UK's Data Use and Access Bill, which is proposing amendments to existing data protection laws. And the idea behind the extension is to provide time for the UK's legislative process to conclude and allow the EU Commission to reassess the UK's legal framework once these new laws have been analyzed. Currently, the existing adequacy decision for the UK from 2021 remains in effect. And so while the EU initially found the UK's data protection adequate, the EDPB is recommending careful monitoring, especially as the UK is developing its own data protection policy. So, for example, like some of the objectives of the UK data bill is to enhance transparency and trust in data handling, support innovation and market competition, provide those clear rules for data access and verification services, and then also strengthen safeguards needed for sensitive data and automated decision making. So they really just want to see how this process plays out. And the key thing for companies is just, keeping informed, understand like which data flows would be impacted by any potential changes. We'll know more, towards the end of this year. Um, why don't we shift over to South Korea?
Yes, so that's another enforcement action from South Korea. So the Personal Information Protection Commission, the PIPC, on DeepSeek, which is a large language model, which is a large language model chatbot from China. So in April, the PIPC held their plenary meeting and provided the status of the results of their investigation on DeepSeek. On the cross-border data transfers, they have found that DeepSeek transferred personal information to servers in China for purposes such as service improvement, security, customer support, and they failed to obtain user consent for overseas transfers or disclose this in their privacy notice at the launch of this chatbot in South Korea. So during the investigation period, DeepSeek updated their privacy notice and they submitted it to the PIPC. DeepSeek used public data, and input prompts for AI development without providing an opt-out function initially. The processing, the privacy notice and the terms of use only vaguely reference data for service provision and improvement without sufficient clarity, as the PIPC found. Under the South Korea's privacy regulation, explicit consent is required from users before their personal information can be shared with third parties. The PIPC decided to issue a corrective recommendation to DeepSeek, urging it to establish proper legal grounds for overseas data transfers, immediately delete user prompts already sent to the Chinese company, continuously secure service transparency, such as disclosing in the privacy notice. There are also a few recommendations for improvement, and they included designation of the domestic agent and compliance with the reinforced personal information protection measures. DeepSeek is required to inform the PIPC of its implementation results within 60 days. So as a takeaway from this enforcement action, the companies need to ensure they assess requirements on the data transfers before transferring personal information from one jurisdiction to another. Mm, the best practice is to understand the data flows and the requirements in those jurisdictions, and failure to do so may result in the enforcement actions. With that, what are the impact on privacy, Joanne? We have talked about the enforcement actions, privacy regulations updates. What are those impacts?
Yeah, and let's go to the next slide. And yeah, and now we've reviewed how data transfer requirements and enforcement are changing across the globe. And this increasing divergence in legal requirements does create a real risk of fragmentation for organizations trying to operate internationally. And to navigate this, kind of ever evolving complex landscape, privacy teams need to be able to answer some fundamental questions. So, first, they need a clear understanding of their current data flows. Where is data going right now? And then once they have that map, the privacy teams need to identify which of those flows are most legally vulnerable and pose the highest level of risk, considering the various rules and enforcement actions that we discussed here. And then for those high risk transfers, the crucial question becomes what additional safeguards can we implement to ensure compliance and protect the data? And then finally, privacy teams will need to consider the practical implications of these changes. How do these new requirements impact their day-to-day operational processes? And addressing these questions is key to effectively managing cross-border data transfers in this evolving environment. So let's, with that, let's dive into some strategies. Next slide. That you can use to navigate this ever-changing geopolitical landscape we all live in, and start to address some of the questions that we've highlighted. First you need to integrate managing data transfer risk into your existing data protection risk management process and identify and assessing that risk as you build your data inventory and records of processing activities. This will help, determine what tools such as like certifications that you're going to need as part of your data transfer toolkit. So first, let's take a look at understanding exactly, what's going on in different jurisdictions and kind of the types of questions you need to answer. Let's go to the next slide. So first, looking at kind of the workflow for managing data transfers, especially as the European Data Protection Board has issued guidelines. China has put, prescriptive rules in place around transferring data across borders. As Machek talked about with South Korea and the DeepSeek case, making sure, you're having that transparency. So this, is requiring companies to understand where the data is going in terms of geographical location. And the approach that we recommend in helping companies do this is that, one, doing that jurisdictional analysis, and we'll talk about, how TrustArc can help you there. We do, help you flag where a company may have data transfer risks based on where the data is going, and doing that jurisdictional analysis. So it, takes a lot of time to research that, and we'll go dive into some of the types of things that have to be researched to really do that analysis. And and what a potential workflow looks like. So let's go into the next slide. So TrustArc, we analyzed over 80 different jurisdictions to address, some of these questions for you. Key consideration being is for data transfers is the risk associated with the destination and the protections in place within that jurisdiction. And there's three main areas that are required assessment for each jurisdiction. So the legal framework, what do they have in place? Does it adhere to the rule of law, recognize a constitutional or legal right to privacy, and acknowledge relevant legal conventions? The next question is around the presence of an independent supervisory authority. Can that authority issue binding decisions and actively investigate complaints from individuals, regardless of the individual's residency or nationality? And then the last key area to look at is government surveillance and data sharing practices. So, what laws govern national public security? Are there limitations on secondary uses of data by government agencies? What are the requirements for accessing data, such as, are court orders or warrants required? And what obligations do telecommunication providers have to cooperate with law enforcement? So those are types of questions that need to be answered as part of that jurisdictional analysis, and understanding these aspects, clarifies the risk and available protections in the destination jurisdiction, and simplifying the risk assessment for vendor management, identifying data processing locations. And now, we can shift and talk a little bit about how we can operationalize this on the next slide, where data transfer risk management does need to be a part of your overall data protection risk management strategy and embedded into your current risk management workflow. And TrustArc has integrated identification into the process of building out a system inventory or records of processing activity process. And TrustArc's approach brings that process, building out your records, and the assessment process to work together to help companies manage that data processing transfer, AI, and vendor risk. So it's your overall data protection risk. And it starts with, creating that inventory, that record where the risk is identified. With data transfer risk, it's based upon the location of the data subject and then where the data is going, for example, like where different systems are hosted. And it, you know, helps identify and flag that particular risk based upon like where the data is being exported to, and then recommending the type of assessment needing completion. And then from there you launch that assessment, and then you can tasks can be generated for remediation and managed. And then you get that residual risk based upon the responses in the assessment and generate a risk report. And the way we think about it is kind of a sandwich of, bringing the, data mapping and your risk management, is kind of like the bread, and then the assessment is kind of like the filling, pulling the sandwich together. And on the next slide, we show kind of the specific steps of, the sandwich and what it consists of. And, this is the recommended process and approach that TrustArc takes. Doing that risk identification, which is, to identify the potential data transfer risk. And then doing that risk analysis and prioritization, once they're identified, then you can prioritize them based upon, the risk potential impact and likelihood. Then kick off that formal assessment process, evaluating the identified risk and the safeguards that you have in place. And then also you can develop an assigned task to address and mitigate any assessed risks that come out of that assessment. And then, complete the task, so assigning risk management strategies and getting those done. You can prioritize based upon what's critical for your organization, and then doing that assessment review and approval. And then lastly, you're able to have that continuous risk management where you can regularly update and review the risk. It's not just a one uh done in one point in time and you're done and off you go. Things change, and these types of risks need to be evaluated on a regular basis. um Yes, and great question. Where we use some acronyms here on the slide: DM, RM, and AM. DMRM is Data Mapping and Risk Manager, so that's where in TrustArc's platform the uh, data processing records, your ROPAs, as well as like your system inventory are created. AM stands for Assessment Manager, which is where you do your assessment. And these, create a risk management platform that, work together. So these are kind of the two components of the sandwich that we're talking about here. Um, and so basically the key thing is having this clear process for understanding your data flows, identifying your data transfer risk. And the next step is to select the appropriate tools for compliant data transfers. While no single solution guarantees compliance, certification is a valuable tool for enhancing the effectiveness of your data transfer strategy. And Machek's going to dive into that further. So, Machek, over to you. Let's talk about how certification is a key part of the data transfer toolkit.
Thank you, Joanne. Can we move to another slide? Thank you. So privacy certifications have been used to build, customers' trust and confidence in an online environment for quite some time. We have been delivering privacy certifications since 1997. We developed one of the first online privacy seal programs. Privacy certifications give participating companies a competitive advantage to demonstrate their commitment to privacy. With many companies having a global presence, selling or providing their products and goods globally, the data, the personal information flows with the products and the services. Companies must keep up with the changing regulations, and customers have high expectations regarding protections of their personal information and security. Here come the privacy certifications. Some of the benefits are customer trust by demonstrating your adherence to a framework, a law. You can reassure customers that their personal information is being handled in a responsible way, leading to increased trust and loyalty. Certifications such as previously mentioned CBPR can enable, greater transparency in cross-border data transfers. In the complex regulatory environment that we have already talked about, certifications enable companies to build their data transfer strategy. Mm, Certifications and verifications are based on sets of recognized principles. So there is interoperability. Most privacy frameworks and regulations in the world are based on the OECD principles. So there is a good interoperability and overlap there. Frameworks such as uh, APEC CBPR, Global CBPR have been negotiated by the governments, which adds additional level of credibility to those schemes. When you go through the certification, your practices, your privacy practices are reviewed by a third-party reviewer. It is an excellent way for companies to have your privacy practices reviewed. It also creates an opportunity for enhancing the maturity of the privacy program. So think about, you are in the process of building your privacy program. You can build your program around the frameworks, around the principles included in the CBPR, even before considering your certification. And also, it is an excellent tool for vendor management. Can we move to the next slide? Another important note and the benefits are at the end of the certification process, certified companies receive a privacy seal that can be displayed on their privacy notice with a long history of providing the privacy certification. Our seal is very well recognizable. Our privacy team of experts here at TrustArc will support you in your work on your privacy certification. Mm, the certifications, the certifications are documented in the TrustArc platform, and most of the certifications include the dispute resolution mechanism. So with that, let's move to another slide and let's talk about what are those offerings in the context of the global transfers. So we offer several certification products that can help companies in building their data transfer strategy. Those products are APEC PRP, APEC CBPR, Global PRP, Global CBPR, and the privacy framework DPF verification. For the CBPR, for PRP, we have been recognized as an accountability agent for both the APAC and the global systems, and we deliver both CBPR and PRP certifications. The CBPR certification is a certification for data controllers. It includes an annual review of data practices. This framework is based on 9 principles, which are operationalized by program requirements. The economies that participate in the global CBPR framework, and some economies, I'm not going to talk about them all, are Singapore, US, Japan, South Korea, Chinese Taipei, and there are also 3 associate members. So for this, think about the status as an observer status. So here we have the UK, Mauritius, Bermuda, and the Dubai International Financial Center. As for the benefits of the CBPR certifications, it is a legal transfer mechanism in several jurisdictions, where those jurisdictions included that in their national laws or agreements. So those examples here are Japan, Singapore, and it was also mentioned in the USMCA trade agreement. This is a very important tool in the data transfer strategy, which adds another transfer mechanism to your portfolio, to your strategy. There is an annual review of your privacy practices. And, joining the global elite of certified companies give you a great competitive advantage. So that's for CBPR. Can we move to the next slide and talk about PRP? So privacy recognition for processors, in short, PRP. This this also includes an annual review, and the scope of review here, the scope, the principles, and the requirements include the data protection and security measures that are applicable to data processors. So some of the benefits include this is a great vendor management tool. So we see a number of data controllers in a business to business relationship that require their vendors to be PRP certified as a tool for their vendor management. You know, recognition by an accountability agent, um, and the adherence to the globally recognized requirements has become a very important advantage of this certification scheme. Um, and yeah, as I said, the accountability when a company gets recognized by accountability agent, you can demonstrate compliance to customers and other stakeholders in the business to business relationship. So that's for PRP. Let's move to the next slide.
Yeah, oh yeah, go ahead,
No,
Machek.
no, please go ahead, Joanne.
Yeah, interesting question that we have is, do we see CBPR ultimately replacing GDPR since it seems to have broader reach? You know, my feeling, GDPR is a, national law that, applies across the EU, where CBPR is a framework, and the goal is of the CBPR system is to have some interoperability across all these different jurisdictions to enable the free flow of data, where, GDPR's purpose is, very different in terms of ensuring the, rights, fundamental rights and freedoms for individuals within the EU. So the goal is ultimately to have the two work together. Machek, you want to add to any
No,
thoughts on that?
no. So to your point, Joanne, when we talk about data transfer strategy, this is not to, we're not talking about replacing anything. We're just talking, if there's one transfer mechanism and the CBPR, where applicable, is adding that additional transfer mechanism to your portfolio.
Yeah, exactly. Because as I mentioned earlier, it's not just one thing and it's said and done. You're going to
Right.
have a combination of, you know, leveraging certification, such as the one that you're about to cover here, as well as other tools like standard contractual clauses, obtaining consent. There's a variety of different things. I could go on all day, but Jack, let's talk a little bit about DPF here.
Yes, and t t talking about the transfer and valid transfer mechanism. So for data privacy framework, DPF in short, this has been recognized as an adequate transfer mechanism under Article 45 of the GDPR, and it allows the participating companies, to rely on this mechanism when they're transferring personal information of the data subjects from the EU, from the EEA. Switzerland has also provided their adequacy decision on this, and there is an extension to the UK. In terms of the key benefits here, this includes an independent third-party review of the privacy program. This is a legal transfer mechanism. It includes, recourse mechanism under the DPF, and it satisfies the DPF assessment obligation of the companies. With that, we can move to the next slide.
Yeah, let's talk about, so what are some of the key takeaways from what we've covered here today? So, you know, one, understanding the regulatory and changes, keep, staying informed about the evolving landscape, of data protection regulations like the new DOJ rules is really going to be critical as you're looking through your data flows and your overall strategies around like, what partners that you're working with, and, where the understand where the data is going. So you have a handle and some insights on, the risks that may be associated with that and be able to effectively make some business decisions around that.
Yes, and you should also get ahead of the regulatory fragmentation. When we talk to other privacy professionals, the regulatory fragmentation, changing requirements are one of the biggest challenges for companies. Interoperability of the framework, such as CDPR, could help companies in building more future-proof privacy programs. Certifications are just a great tool to help with this.
Yeah, and and then staying on top of those regulatory changes, put a little plug in for my team here in terms of our NIMIDY research solution. That is what my team does all day is looking across all these different global regulatory developments to help you keep apprised and up to date. But also, to our third key takeaway here, prioritize that visibility and documentation. So this is one of the key components of ensuring that you have all the operational components for your program. So making sure that you're maintaining those clear records of data processing activities, and you're able to demonstrate, that adherence to the regulations because you have that visibility into your data flows, what data is involved, where it's going, so having those clear records is going to help you do that.
Yes, and for your transfer strategy, review the requirements in the jurisdictions that you transfer personal information from. Work towards achieving your privacy certifications such as CDPR to build your transfer strategy to add another transfer mechanism to your portfolio. The scheme has been negotiated by multiple global economies, and there are jurisdictions that recognize it as a legal transfer mechanism.
Yeah. And also, in our last takeaway here is start with that structured mapping. Begin with this systematic approach to understanding your data flows, and then utilize pre-built data transfer impact assessments to help streamline your risk evaluations for data transfers. The requirements across these different jurisdictions can be complicated, and you know, we want to ensure that the tools that are there help you navigate these different waters. So the question that we got is, which product of yours has a pre-built transfer impact assessment? So that goes into our data transfer management workflow, the combination of our data mapping and risk manager and assessment manager. They are designed to work together to give you a full view and picture into your data transfer risk. And our approach is, since we've done the jurisdictional analysis for you through our research product, our assessment focuses on the data protection safeguards that you have in place, ensuring that you have the appropriate safeguards based upon where the data is being transferred out of and where, because we've already done the analysis around where the data is going. Um, I hope that answers the your question there. Want to thank you, our audience, for attending today's webinar. It was a pleasure spending some time with you here today. Thank you.
There, everyone.